Good morning, everyone, and welcome to this webinar hosted by TDS and Painsmith Solicitors. My name is Michael. I'm Head of Product at TDS, and I'm going to be hosting today's session. Morning, Laura. Morning, Marvin. Hope you're well.
Good morning, Michael. Yes, ready to go.
Yes, so we've got a really interesting session today on guarantors. Marvin and Laura will be discussing, drafting a guarantee for a tenancy agreement, references, conditions, and some other really important points to ensure that you get this spot on. Just a little housekeeping for those of you still joining. You can use the pen and pad icon to take notes during the session, and these can be emailed to yourself at the end. If you have any questions, there's a space to ask them on your toolbar. I may answer some of these as we go along, but I intend to keep 15 to 20 minutes at the end of the session to try and answer as many questions as we can. And finally, if you have any connectivity issues, please just refresh the page. If that doesn't work, you can close the browser and re-enter during the session using the link which has been sent upon sign up. So without further ado, we're going to delve straight in, and Laura, I'm going to pass control of the slides over to you so you can manage at your own pace.
Okay, thank you.
Right. Good morning, everybody. I'm Marvin Smith. I'm Principal of Painsmith Solicitors, and my colleague Laura Simpson will be speaking during this seminar. What we're speaking about today is guarantors. Why do you need a guarantor? What should you be doing to protect yourself? What you've got to remember is we see everything that goes patently wrong. We have at this point in time, Laura told me yesterday, a case in at the minute, and the guarantors are students. Well, students are usually not a bit flush with money, and that's no protection to you, the landlord, or helping you, actually, the agent, guide your landlord. So let's look at why have a guarantor. Your guarantor is there because basically many tenants now cannot pass referencing well. They cannot afford the liability for the rent. You need something to protect you, some way that you can easily get your money.
So Marvin, just to interject, I've transferred the session over to yourself, so you can control the slides.
I haven't got any slides up. I've just got guarantors and obligations up. I can't get them up.
Try again now. Is it popped up to ask you to take control?
No.
You should be able to flick through the slide deck now on screen.
Just as guarantors and obligations, the session will begin shortly.
Yes. Are you able to flick through that though?
No, it doesn't give you the option.
No.
There we go.
Oh, just hang on a minute. Yes, I've got
Perfect.
it. I've got it now.
Fantastic.
Wait a minute.
I think you're flicking through them. Do you want to go? There we go. Perfect.
Good morning, everybody. Now I'm actually with you all. I shall start again. Right, why have a guarantor? The guarantor is there for the protection of the landlord, and you need to make sure that you have done everything to help yourself. We see when it all goes wrong, and we see the dreadful guarantees that come into this office. So the object of today's session is to say, right, you get a guarantor. What do you do to protect you, the landlord? What does your agent, you who are agents, what do you do to protect your landlord? And how do you make your guarantee really tight? I must admit, I'm well known in the industry and that my guarantee probably allows a guarantor to breathe twice, but I'm not even sure about that. So first of all, let's look at liability. I was quite appalled recently when I was speaking to one client, and they said, oh, no, we just get the guarantor to guarantee rent arrears. I said, but how about damage at the property at the end of the tenancy? Oh, no, we don't bother about that. How about this? No, we don't bother about that. Is your guarantee absolutely rock solid? You need to be indemnified, not was indemnified, guaranteed, get your money back for rent arrears, all rent arrears, any loss or damage at the property. So that's any damage by any person at the property, which is whether intentional or not, if it's their fault, and any breaches of the tenancy, where there's costs arising. Does your guarantee cover that point? If not, you need to go back today and do something about it. It is not sufficient to get mum or dad to write, I guarantee my daughter. What are they guaranteeing? Or I pay my rent, my daughter doesn't pay. You need a document that clearly indemnifies you, so the guarantor is going to pay you if any of these arise. Also, what is he guaranteeing? Is it just the original tenancy from, say, September the 1st, 2023 to August the 31st, 2024. But what happens if there's an extension or a renewal for a fixed term, or continuation is periodic? Are you covered for that as well? If you are not covered for that, it means you could go back each time and get a guarantor to re-sign a document, which is definitely not in your interest. We want to keep the continuity there so that he's liable for everything. The guarantor should be paying for absolutely everything, the whole tenancy. Now, you've got to make sure that you do notify him if there's any renewal or if the tenancy becomes periodic. Dear guarantor, the fixed term ends on August the 31st. The tenant wishes to renew. Your guarantee will therefore continue. You've still got liability. And we point to your guarantee, back to guarantee, dated whatever. So if you've informed him in writing, email is usually fine for this, provided your service of notices clause allows it, then otherwise he will be liable throughout the whole fixed term. The guarantors can't change their mind or resign quite that simply, as we get day after day in the office. We want to resign as guarantor. No, you've signed this document, it's legally binding. You need to make sure you're covered. So go back now and look at your guarantee. Is it for everything? Rent arrears, damage, breach of the tenancy? Is it not just for the fixed term, but any continuation whatsoever, as long as that anybody forming that tenant remains in the property? And listen to the words I said, everybody forming that tenant. So everybody who is the tenant will be named on that document, all four of them. And as long as any one of them remain in that property, your guarantor remains liable. So have a look at that at the end of this session and just check your guarantee says that. Now I'm going to hand over to Laura, who's going to speak about the liability of the guarantor. And again, these are things you really need to take carefully because it affects you and how you're going to protect yourself, or agents, how you can protect your landlords to make sure they're covered. Laura.
Yeah, absolutely. So when we're thinking of liability, we want to try and determine what can you hold them accountable for. So as Marvin's alluded to, if you have, say, 4 tenants and they're all listed on the tenancy, they'll usually have joint and several liability. Now, ideally, you would like the guarantor to have that same level of liability. Now, what does joint and several liability ultimately mean? Well, this is where if there is one or more people that comprises that unit, whether or not they be the tenant or the guarantor, they are responsible to comply with the terms either collectively as a group, or they can also be pursued as an individual. And ultimately, that means then that the guarantor can be held liable for the complete debt in the same way as the tenant. We'll talk a little bit later on why this might be important, particularly from an enforcement point of view. Marvin talked about whether or not you should be notifying the guarantor of intended changes to the tenancy. And we've seen that obviously that is an absolute must if you wish for this guarantee to continue and the level of liability to arise. Now, that same position will apply if there are going to be changes within the tenancy agreement in terms of the tenants themselves. So if the guarantor has not been informed that there is going to be a change in tenant, this may well affect the deed of guarantee as to whether or not that liability will still remain. We often find that we are asked questions, particularly with students, as to whether or not they can just guarantee their son and daughter. Now, in practice, this is difficult, particularly if you are joint and severally liable, because son and daughter is also responsible for the rent of their friends, whether or not they pay it or not. So therefore, how can a guarantor guarantee just their named child? Now, one way of getting around this may well be to offer a percentage reduction in terms of liability, but this is not something we recommend. So, for example, in the event that you have 4 tenants and each has a guarantor, you may well say each is liable for 25% of the debt. How will this ultimately work, you may ask, in practice? Well, when it comes to enforcement, yes, what are you ultimately going to get? Now, as a landlord, you'll need to decide, do you want to have the ability to pursue that individual for the full debt, or limit the ability to claim for them for that 25%? It may well mean, when you look at who is capable, for example, of actually paying the debt to you, how much of it they are actually required to give you. You may well find that as a result of that decision, you end up with a bit of a shortfall in terms of how you ultimately recover that money. So as you can see, there are potentially pitfalls in terms of having that percentage, but it is something that is possible if you are an agent and a landlord is requesting that, or the guarantor is. You should really get the explicit consent of the landlord, making sure that they are aware of those potential risks. And the other question is, how many guarantors can you have? Well, in principle, you could have unlimited numbers. I suppose in reality, you'll need to determine whether or not they are viable guarantors. And also from a paperwork perspective, does that create a bit of a headache? I mean, a decision for you guys to make.
Thanks, Laura. By the way, as Laura says, I draft all the documents here, and I drafted the joint and several guarantee agreement. And there's a lot of pressure to do the limited liability, which I dislike intensely. I prefer each guarantor to be 100% liable. And as Laura said, Laura will tell you how she can enforce that. But it means that actually, if you find out the richest and go for that one person if you can, it makes life so much simpler for everybody. So let's think about this guarantee and how you're going to create it. You get the guarantor to sign the tenancy agreement, you're wasting your time. If there's no obligations for that guarantor in that tenancy agreement, he or she is not liable for anything. So how are you going to do it? I like a separate guarantee agreement because it actually concentrates the guarantor's mind and his obligations. But do remember, you've got to put a copy of that actual tenancy agreement at the back of that guarantee so you can see his obligations. Obviously, it's not a signed copy. We're not actually got to the stage where everybody's signing anything till we get this guarantee back. You can have a separate guarantee with a copy of the tenancy agreement attached. On the other hand, if you do not want too much paperwork, you could have your tenancy agreement with 3 sections effectively: obligations of the tenant, obligations of the landlord, and obligations of the guarantor. And each party sign the tenancy agreement. Now, can I just pause there? I do not mean that each party signs, that all the parties have to sign one document. You don't need that at all, especially when people are all over the country and look at electronic signatures. Then basically, you could have about 10 different copies of that tenancy agreement, especially if you've got 3 or 4 people who are going to share this property between them, and they're all in different places. And each person may sign a different agreement, unless it's electronic signatures. So easily, the guarantor does not have to have any signatures on that tenancy agreement before he actually signs it himself. So you do draft 3 copies of your agreement, one for the landlord, one for the tenant, one for the guarantor. Maybe a lot more because you've got more tenants, you may have more landlords, you may have more guarantors. But that's the 2 ways of doing it. Now, there's 2 ways of drafting a guarantee. You have a guarantee agreement, nice and simple. What is wrong with that? Well, supposing you have a bit of a hissy fit, the landlord signs it, tenant signs the agreement, we date at the top. It might even come off your computer with that date, which is legally wrong, and that should be crossed out straight away, because that actually can compromise the situation. And then we should send the copy signed by the landlord to the tenant, and vice versa, and we have had our guarantee back. What's the situation then? You're up a creek, no paddle, because if that guarantee comes back late, it's just a guarantee agreement, it is void. You cannot enforce it in a court of law. Now, obviously, you're not going to tell that to the guarantor at this point in time, but you know as well as I do that you're then very vulnerable. Now, there's another way of doing a document. It's called a deed, and everybody is terribly frightened of deeds. All that really means is it's got to be in writing. So, in theory, your guarantee doesn't have to be in writing. You try proving to anybody what you and the guarantor agreed if it's not in writing. So your deed has to say at the top of it, this deed of guarantee. And at the bottom, it has to say, signed as a deed by the landlord, signed as a deed by the guarantor. And both signatures have to be witnessed. Your normal guarantee agreement does not need witnessing, just like your normal tenancy agreement for 3 years or less does not need witnessing. You don't need witnesses, although I must admit, in our industry, we're all very, very prone to actually doing witnessing because we all feel safer that way. But you don't, by the way, if a guarantee comes back to you, a guarantee agreement, or a tenancy agreement is not witnessed, you don't witness it yourself because you actually do not know how that was the person who signed. So be careful there. So you do not need a witness if it's not a deed. If it is a deed, then it must be witnessed. Why would you even want to think of the deed? Well, just in case we had that hissy fit and everything's signed and dated, and we have their guarantee back, and it comes back 2 days later. If it's by deed, it's enforceable. And agents, you're acting for the landlord, so therefore it matters to you. And landlords, you want to protect yourself, so it should matter to you as well. So consider that. It's just tweaks and wordings. That's all it means to you at this point in time, but it could be quite significant at the end of the day. Now, how about electronic signatures? I think that's pretty very good. The Law Commission says you can use them. The Law Society says you can use them. However, I would say just be careful. We had a judge in a recent court case who said an electronic signature didn't look like a real signature, therefore he wasn't going to grant possession. It was in this case. And so therefore you do have to be careful. But that's because the judge is in that county court and they have no idea what he's going to say. He's the chief actor on the stage. We have to put up with it. But the great thing about your guarantee, for example, just like your tenancy agreement, that can go out to all parties. And if it's an agreement, they can sign it. So what happens if it is a deed? In theory, Law Commission, etc., say, yes, you can do the same for a deed. But can you tell me how you're going to prove that that witness was in the same room as the guarantor when he actually signed that deed? Almost impossible to check. So if it's a deed, electronic signatures do not work perfectly well, and you may have to go back to what we all call now wet signatures. In other words, get somebody to actually sign it, which of course does delay matters, and you need to take that into account. And by the way, never, ever, ever give the guarantee to the prospective tenant to take home to mum or dad or anybody else. The chances are that, and we've seen this before, by the way, I have, they go down the pub and get one of their mates to sign it. We had one actually where father proved by sending in his driving license with his signature on it, they definitely hadn't signed it. Mind you, the agent was quite smart in that one. She said, oh dear, Mr. Smith, that means your son's committed fraud. I will have to report it to the police. And he's graduated this year. That might affect his job prospects and where he can live. Father paid the next day, but that's called blackmail, so I don't recommend it to any of you. So just be very careful. Other thing to consider, what's the relationship of the guarantor to the tenant? The closer the relationship, the more likely they actually will honour it. We get so many guarantors who go, I didn't know what I was signing. I was just helping a mate. They forget they have to pay out. Or we get muddled tenant's mummy going, I don't know what this is, but we've paid our share of the rent, which is quite horrified to discover that she's now jointly and severally liable along with her daughter for all the rent. So the relationship does help. I've mentioned incorporating it to the tenancy agreement, but you must make sure that the obligations in that tenancy agreement are shown to all parties. If they do not see that tenancy agreement with the obligations they're guaranteeing, they can argue they're unaware of those obligations and therefore they should not be liable. And again, I'm going to emphasise, make sure that guarantee is signed before your tenancy. You have signatures in the tenancy agreement. You don't even have a date, but you do not exchange them past the other parties until you have actually got that guarantee back there from every single person forming the guarantor. Probably 4 separate documents. Check you've got them before you bind yourself, and agents before you bind your landlord. Be very careful at that point. It's becoming a big issue because guarantors now, when they do realise the obligations and the legal costs involved, are trying to weasel out of everything. So make sure you've actually checked yourself. Right, I'm going to pass over to Laura, with me now, sorry. Right, other considerations, what we're going to deal with here. Right, now let's look at some of the things in your guarantee and things you need to think of. Is the guarantor paying the deposit? We all know for youngsters, Bank of Mum and Dad is the best thing ever. If the guarantor is paying the deposit, make sure you show it on the prescribed information. That's crucial. This isn't the guarantee, but it goes alongside the guarantee. We do not want to give the guarantor any reason to try and slip out of his obligations. Make sure it's there. And I also recommend that you put a clause into the tenancy agreement that says the deposit was paid by Dad and will be returned to Dad at the end of the tenancy, less any deductions agreed between, and listen to these words, the landlord and the tenant, not Dad. Dad's not part of this contract. He's not part of this tenancy agreement. He has no rights over what the deductions are to be. Make sure you clearly have that clause in that tenancy agreement. Partly because Dad will be a bit miffed if it's his daughter and boyfriend who are in that property and they split up and boyfriend's expecting 50% of the deposit he's paid. So it does help with the relationships that way, but make sure you actually state exactly who it goes back to and any deductions. Now, what credit checks are you doing? You need to ensure that guarantor can meet his ordinary obligations as well as the obligations of that tenancy agreement. You need to be very careful here. There has been a High Court case, agents, by the way, where references were taken up just for a tenant. And what happened is the landlord sued and said that it was obvious when he saw the references because he wasn't showing them. And remember, landlords, you should see the references from the very beginning. You're entitled to. But when he was showing the references, it was obvious they were pretty rough and pretty bad. And the agent had done nothing about it. And the agent tried to argue that basically they relied on an outside a third party. But the judge said that's not enough. When it comes back, you should read them and check those that they actually can meet those obligations. So all of you as landlords, all of you as agents, make sure you check these references, make sure the person can reach the obligations. For example, we don't want, as Laura's just got at the minute, in fact, where the guarantors are students. We don't want anybody on the state old age pension. We don't want anybody who's got no assets whatsoever. I'll come on. Do you want anybody who's abroad? Well, you can't say, well, actually, you're French, I'm not taking you. That's racial discrimination. What we can say, though, is, where are you located? Where do you live? I once had an agent who said that he had a lot of Greek students, and he wasn't bothered because he was pretty sure the Greek government would guarantee them, and therefore, if any didn't pay, he'd go back to the Greek government. Well, knowing how well the Greek government's doing just now, I don't think that's likely. And also, I think he was actually in a wing and a prayer. So you need to make sure that can you actually get that money? If the person's located in anywhere in the EU, or even worse, America, US, that means you get your, as Laura will explain, get your judgment here. But how are you going to enforce that abroad? How much is it going to cost you? I must admit, I know no Spanish law, no French law, or anything, and I'm pretty sure the same cost a fortune. So what we can say is the guarantor of any nationality, as long as he's resident in the UK. I know Scotland and Northern Ireland are separate jurisdictions, but it's pretty easy to enforce. So, and his assets in this country. In other words, we want something we can easily grab. We do not want to find out that the only place he's got assets is in the British Virgin Islands, in which case you're totally wasting your time. So make sure the credit checks are done properly. Make sure the person has got the money. Make sure he lives in this country and, if possible, has got a good job and a very nice house. Because houses are really useful for being able to get money back, even if it's long term. So have a good look at that and consider it. Now, Laura's going to speak about other points with this, so I'll pass back to Laura.
Thank you. So yeah, Marvin's already touched on the fact that relationship with the tenant is important. And why is that, you may ask? Well, we need to establish whether or not they are ultimately going to be a viable or useful guarantor for you. What is the purpose of the guarantor? Well, as we know, it's to try and recover as much of your losses as at all possible. Therefore, the impact in terms of that relationship can be really useful. For example, mum, dad, guarantee son, daughters, they are potentially more useful in the sense that they are less likely to want to see their son or daughter homeless. But also they are less likely, having brought them up and now out on their own, renting, studying, whatever it may well be, they don't want them to then adversely have any credit rating that may impact their ability in the future to get loans, houses, mortgages, anything like that. So they can often be considered quite useful guarantors. Your friend, a colleague, somebody that you've met at the local pub is unlikely to be as willing to stump up cash on a regular basis and may well think, well, actually, you've put me in a bit of a situation. I don't really care what happens to you. So it's important to take that into account. The other issue, I suppose, to think about in terms of relationship is also grandparents. Are they nearing retirement age? Have they retired? Do they have a regular income that they can support themselves for the remainder of their life, but also support the tenant? And in reality, possibly not. It is also important to think of when they are signing a deed of guarantee, have they understood? Have they had the opportunity to take it away and read it? Are they being put under pressure by that tenant? Grandparents, again, potentially may feel that they want to help them at all costs, but has the tenant put them under pressure? And that is something, have seen argued in the court in terms of trying to defend and try and prevent a judgment being made against them. So really important to try and cover off as many of those potential defences as possible. So you're not left in a situation where actually you may not be able to rely upon that guarantor. So when do we pursue the guarantor? Well, there are a number of opportunities in which you could pursue the guarantor. One may well be during the course of the tenancy, or in the event that the tenancy has in fact ended. Now I'm going to talk a little bit later about where you may well be able to use the breach to end the tenancy a bit later. So for this section, what happens if the tenancy is ended? Well, who can you locate? A tenant may well, having occurred or built up this debt, may well have absconded and you have no means of working out where they are. You may well have tried instructing tracing agents and no viable address has been located for them. However, you've got a guarantor, you know where they live. You do not believe that they've moved, or a tracing agent has identified that they have not. Suddenly you've got a very viable option in terms of pursuing that guarantor for that debt. If indeed you are in the course of the tenancy still, you will need to weigh up what is it that is the ultimate aim. Is that gaining possession? And as we see with the Renters Reform Bill that's being proposed, if you lose the ability to serve a non-fault based notice, you're going to have to rely on a breach. If you've got to rely on a breach, you need those rent arrears in place to be able to then obtain possession of the property. So is your aim to obtain possession, or is it simply to get a money judgment for the arrears? If you make a small claims court application for the arrears during the course of the tenancy, this may well affect your ability, firstly, to obtain possession, but secondly, will limit how much you are able to claim as part of that claim. So you can only claim the rent arrears that are there, present at the time of making that application. That doesn't take into account, therefore, future rental arrears that may occur whilst the tenancy remains ongoing. It's important to note that you are not required to limit your losses, and you're therefore not required to limit the losses of the guarantor. The guarantor, and I have also seen this, has put pressure on the landlord perhaps to serve notice to end the tenancy because they are fed up of keep paying and bailing these tenants out. That, again, is it possession that you're after? Because you may be quite happy for the guarantor to continue paying their rent as they're obligated to do so. And if a guarantor continues to pay the rent, then again, you may well not have the grounds to even serve notice. So, you know, worth considering. What it is the main aim. And when do you inform the guarantor ultimately of that debt? Well, again, depends on what action you think you've taken. Certainly, you would need to inform the guarantor before you take such court action. They must be given the opportunity, for example, to remedy the issue and to pay the debt. You don't ultimately want to incur legal costs if the guarantor and or indeed the tenant is then going to ultimately pay the amounts that are owed to you. If you are looking to issue court proceedings, what is that on the basis of? Is it the rent arrears? Is it serious breach? So has there been damage caused to the property? Again, timing of that is important. Do you do it during the course of the tenancy and limit your options, or do you wait until the end? Once you have gone to court and hopefully received a successful order and you have a judgment from the guarantor, you then have a decision in terms of what to do next. Now, just because you've got a judgment doesn't guarantee that the guarantor is going to pay what is owed to you and what the court has ordered. It may well require further action, and that's called enforcement. When it comes to enforcement, there are a number of options that are often available to you, and this is where, you know, we were talking about as well, you know, who is it viable to do it again? And where Marvin mentioned, you know, the wealth of the individual is particularly important. You know, for example, Marvin and Michael are students in a property, and I'm the guarantor. The landlord determines that the students, well, they're not working at the moment, so they haven't got any money. They're never going to be able to pay me what I'm owed. But I'm the full-time employee. I have a house. I've got things that you could enforce against. You know, is that an attachment of earnings order against my salary? Are you going to put a charging order on my house? Am I going to lose that because I've now got this order against me? You know, so it's important to try and work out, you know, what do we know about these individuals, their assets, where they are. Obviously, things change. They always change. You know, people can be made redundant. People can default on mortgages and lose houses. You know, nothing is ever a guarantee. But once you've got that judgment, there is 6 years in which you can enforce it. So the situation of the guarantor and or indeed the tenants can change in that time. If you have rent guarantee insurance, then obviously that may well have covered and guaranteed the rent, and you may well be able to recover that from your mortgage provider, your insurance provider. Or alternatively, some may offer you services to recover fees for taking legal proceedings against any form of breach of tenancy potentially. So it is worth checking your policy, and or if you haven't got one already, looking into what the different policies ultimately cover you for. I think we're back over to you, Marvin, for the issues.
Right. Before I go to issues, just one thing. Laura mentioned mitigating a loss there. So if somebody, let's say you've got tenants there, they've left early, 10 months, 12-month tenancy, do you have to relet that property? The short answer is no. There's actually a Court of Appeal case for it, which I'm very happy to give to Michael to pass on to anybody who wants it. It's called Reichman v. Beveridge. And basically, the landlord can leave that property empty to the end of the tenancy. He does not have to lower the loss of the tenant. Therefore, surely if you've got a guarantor, and you, especially if you've got student property or property, it's the wrong time of the year, it's mid-January or something, it's better just to say to the guarantor, the tenant may have left, but you've guaranteed this whole tenancy. Therefore, you're liable for the rent for the next 2 months. And any damage or any other losses I suffer, it could be utilities, everything else for that period of time. Bear that in mind. Mitigating loss applies to a lot of things. You do not have to do it with a tenant. There's a lot of court cases on that matter. Now, let's look at the guarantee. We've covered, we said we're going to do all the period the people are in there, whether it's the original tenancy, renewals, periodic, fixed term, anything like that. How about a rent increase? I hope, by the way, you all have rent increase clauses in your tenancy agreement. Otherwise, if it goes periodic, you've got to do a Section 13 notice, which if it goes to first tier tribunal will cost you a fortune. So make sure you've got a rent increase clause in that tenancy agreement annually. But remember, if you're expecting the guarantor to pay that rent increase, you've got to inform him. So perhaps a month before, dear guarantor, referring to clause 6.7 of Schedule 3 or whatever it is, the rent will now rise by X amount, and that's it. Now, what if he refuses? Well, he can refuse. You say he's signed a contract, he's bound whether he likes it or not, and he's bound to that increase. But if he's not going to pay, I think this is where you're a bit more pragmatic and decide, okay, if he's not going to pay this, I'm going to have problems with him. Do I just end this tenancy? Do I re-reference the tenant and have no guarantor at all? I'd be very wary of that point. I prefer to be, I'm one of these people who think, oh, if there's any problems with it, just get rid of the whole lot at the end of the term and we'll actually sort it out and we'll start again. Now, you might not be able to do that if the Renters Reforms Bill comes through as I see it as present guise, which is not exactly landlord friendly. So we have to be more pragmatic there and just say to the guarantor, you've signed this document, you don't pay that rent increase, we take legal action against you, it will affect your credit rating. It might not go down very well if we do an attachment of earnings order and send that to your employer, especially if you're a director of the company or somebody quite high up in the company. It doesn't look terribly good that you can't manage your affairs, your financial affairs very well. So there's lots of ways around that, but make sure you've got the rent increase there and make sure you inform them in advance. It's really important. Now, what happens if one person forming the tenant changes? Okay, you've got a couple. We actually had this once. And this girl was in the property of their boyfriend. They split up and she moved somebody new in 2 weeks later. And Mummy, who was the guarantor for both, wasn't terribly happy. And because Mummy was ex-boyfriend's mummy, and she was now finding herself guaranteeing the ex-girlfriend and the new boyfriend. I'm laughing as I say this. I actually have that in my guarantee, that even if one person changes forming the tenant, the guarantor remains liable. And of course, people don't think of such situations. They're afraid that's fact. And it's up to them. You should always tell them to take legal advice from Citizen Advice. It's not Citizen Advice Bureau anymore, by the way. They're posh now. Citizen Advice or a solicitor. They won't. But if you've warned them of that liability and they've done nothing about it, they can't be very surprised when it actually creeps up and they've got to pay. It also probably saves you a lot of hassle if you've got, say, 4 people sharing or 4 students or whatever. One leaves and you agree, you don't have to agree, another person moves in, then basically you can, the guarantors remain the same. You may choose to get another guarantor, it's entirely up to you. I think you've got to be pragmatic in these situations. If you've got that original guarantee, giving you that flexibility is very important. Next thing is, what happens if the guarantor dies or he becomes bankrupt? I always say slightly tongue-in-cheek as death won't let you get away with it. But seriously, in your guarantee it should say, even if the guarantor dies, his estate becomes liable and they will have to pay the debt, any debt arising from this tenancy. The guarantor goes bankrupt. I hope not, because if you've done your references properly, it should not happen. Make sure that you've actually said, if he goes bankrupt, that the landlord stands as one of the creditors with the trustee in bankruptcy. Make sure that's in your agreement. Other 2 things to put in is the jurisdiction of the courts in England and Wales, just so everybody knows, and also a clause for service of notices. What do I mean by service of notices? You've got a clause in your tenancy agreement regarding this fact. You do not want to serve anything, by the way, by registered post or first class or recorded delivery. If a guarantor is thinking you're going to send something that way, he probably would even accept it and sign it. Make sure you've got a service of notices clause allowing you to serve documents and notices on the guarantor by first class post, hand delivery, and email. Now, I do not like legal documents just being served by email. I would always say serve them by first class post. Remember, you've got to allow 2 working days for delivery. A working day excludes a Saturday, a Sunday, and a bank holiday. And I would then attach that letter and any other documents to an email and send it to the guarantor. So you make sure you've got practical ways of serving it. Because actually, if you've got nothing in that agreement, it probably means you've actually got to go and knock on his door and put it into his hand. That's a bit impractical if he lives in, I say, Newcastle on Tyne, unless you're a landlord coming into this from Newcastle on Tyne. So be careful there. Make sure that you've actually got all that in your tenancy agreement, your guarantee. It may be the tenancy agreement, so you may not need it if it's the guarantee is part of the tenancy agreement. It's a separate guarantee. Make sure it's in the guarantee. And I like every page initialed as well, by the way, just so somebody cannot say that was not an original page in the document. Now I'll pass back to Laura, who's going to tell you what, if it all goes pear-shaped and you want to go to court, exactly how you get the guarantor, because we've been quite shocked recently of people not having taken any action against guarantors and being left in limbo, even when there's possession proceedings against the tenant. So Laura will finish off this with you and hopefully not frighten you to death anymore.
Yeah, thank you. Yeah, as promised, this is now going to be the part of what happens if you still got the tenant in situ and there's been a default. What action do we now take? Now, there are obviously two ways in terms of what you can do in terms of getting the tenant out. One is at the moment serving that Section 21 notice, and the second, the Section 8. Now, at what point do we perhaps consider including the guarantor as part of those proceedings? Well, there is often a misconception, and as it says at the bottom of that slide there, my solicitor says that I can't have two court actions. Well, yes, you can't have necessarily two court actions taking place at the same time. So you wouldn't be considering relying on a Section 8 for breach of tenancy and a money judgment against the guarantor running at the same time as two separate claims. But why not consider joining them? So you're looking at issuing proceedings to court for possession, and there are renters. Usually you're going to go down the traditional route in which you're obtaining a money judgment for those arrears at the same time anyway. So you could consider including the guarantor as part of that process. Also, effectively killing three birds, one might say, with one stone. An order for possession, an order for the money judgment against the tenants, but also the money judgment for the guarantor. Not only does that potentially save you time, but also money. You're not doing those two applications, and you've not got that headache of trying to work out where these parties are. You know where they are at this point. They're still in your property. Your guarantor is still guaranteeing. So when do you inform your guarantor? Well, as we mentioned earlier, you have to inform the guarantor prior to taking any court action. Now, as we've mentioned, you may well be looking at serving a notice on the tenant. So include a copy of that notice to the guarantor at the same time. Provide them with the same opportunity and length of time to come back to you and rectify the breach if they intend to do so. Or if not, enable you to evidence that you've notified them as part of those proceedings. It is not possible to continue without notifying them and giving them that opportunity. The last thing you want is for you to go to court and suddenly lose all your grounds because that's the first time which they've seen that there is that issue, and then they rectify it before that proceedings. Otherwise you will lose your grounds for possession. A guarantor from time to time may get fed up with bailing out a tenant. So knowing that possession action is being taken as part of this process and they're not just being required to pay the rent may well assist in terms of preventing them from paying. Now, obviously, there is a downside for a guarantor in the sense that if a money judgment is made against them as part of those proceedings, it will also impact them. That they will have an adverse credit rating, particularly if that is registered as a CCJ. And as Marvin said, if you are a director of a company or similar, then it's not going to look good. So it doesn't mean to say that a guarantor, won't defend a matter or create trouble at the proceedings, but it is something to consider, and certainly something that can be done relatively successfully. There are a number of pitfalls, I suppose, that we do see, and you want to try and limit as at all possible. One of those is certainly the terms that the guarantee has and how they have been communicated. So has the guarantor actually had a guarantee agreement that they have signed? Does it actually stipulate and make clear what their obligations as guarantor is? The amount of times that we have seen ASTs where they have simply initialed, signed, or they've been named in the tenancy agreement, it is far too common, and ultimately it means nothing. You wouldn't be able to issue proceedings relying upon it. The court would simply state, it is not just, it is not reasonable for us to be making an order where it has not been made clear that the guarantor knows or is informed of what their responsibilities are. So there certainly isn't enough. Yeah, I mean, there are a number of ways in which we can try and obtain or issue proceedings against guarantors. Most of those have been obviously now mentioned, but it is, what is your main aim? What is the purpose? I think it's probably a good point at this point, Marvin and Michael, to see if there's any questions, or if there is anything further that everybody would like to know.
Yeah, fantastic. So much useful information in there. So a huge thank you to both of you, Marvin and Laura. We've got a wealth of questions coming in, so I'm going to delve straight in. We'll try and get through as many of these as we can. So the first one that's come up, if your guarantee states that it continues after the end of the fixed term and into a periodic term, do you still have to give written notice to the guarantor when it becomes periodic?
I would say yes, you do.
Yeah.
Because he's got to know his obligations are continuing. It gives him too much opportunity to try and use the phrase weasel out, which is not a very good legal word, but it's very graphic, if you don't tell him.
No, that makes sense. And I think tied to that, we've got a question that's come in. If the tenancy agreement has moved to a periodic in the last 6 months and the guarantor was not informed, can we retrospectively ask for it to be guaranteed again, particularly if we're considering a rent increase?
If you haven't told them, I tell them now. I just say it happens on such and such a date, and then say, and also you're warning them there's an increase. Now, it is a slight risk there, but rather than ask them to sign a new guarantee or anything, I would do that initially, and only if then they try and quibble about it when I think about getting a new guarantee. Would you agree, Laura?
Yeah, I mean, obviously it depends on the clauses, I think, within your deeded guarantee also. I know ours covers, the fact that it continues even if it can, does go into a periodic state. So if you can rely upon and point them to that clause that they originally signed, then that's got to be worth a try as well.
That makes sense. The next question, all contracts in Wales have recently changed. Can a guarantor withdraw and no longer be liable when these contracts are changed?
Over to you, Marvin.
I've been doing a lot of work with a very big agent in Wales on this matter. And my gosh, you poor Welsh people, it is awful. But don't laugh, English, because I think actually Michael Gove's got the story for you is even worse. It doesn't actually deal with guarantors. So I would try strongly to say, no, the Senate didn't think of a guarantor. They haven't thought very much, actually. I would say, no, the guarantor remains liable. Because effectively it's down to basic contract law. It is not part of the Welsh bill, the Welsh Act, rather. So I would say, no, he's still liable. I'd probably also say there's no case law for it. So at this point in time, I would tell the person they're liable.
Fantastic. We've got a couple of questions that have come in about the court case that you referenced, the High Court case where landlords do not need to mitigate their losses by finding new tenants. Was you able just to reiterate what that court case was for some of our attendees?
Yes, it's one of my favourite cases ever, by the way, because of a firm of solicitors that went bust. I always say their fees weren't high enough. It's a commercial case, applies to residential. It's called Reichman v. Beveridge. I'll make sure I send it to Michael to save me spelling it out. And what happened there, it was a 5-year lease. The tenants went bust, and the landlord had 18 months left. He didn't do anything about it. And you can't sue for rent due in advance. You can sue for rent due in arrears. So at the end of the fixed term, he sued for 18 months rent. And the defendant, who had been the tenant, said, that's not fair. He should have mitigated his loss. And the judge said, oh, no, he doesn't have to mitigate his loss. He can leave the property empty and sue for back rent. I know many of you with residential tenancies have got mortgages, and it's not necessarily open to you. But the tenant says, you've got to relet it. The short answer is, no, you don't. And that's a Court of Appeal case, by the way, so that's enforceable. So make sure you realise you do not have to pander to any tenant who wants to mitigate a loss.
Fantastic. Next question, should the guarantor be sent all documents that the tenant is given at the start of the tenancy, such as the gas certificate, the EICR, and any renewals during the tenancy?
Do you want to answer that, Laura? I would just say, I think it's prudent to do so. Do not give them any scope for saying that they're not reliable because the tenancy was not correctly set up. I'd send everything to them as well.
And certainly, and I think you'll probably have more to say on this as well, Michael, but if it's the deposit that they've actually paid as well, and prescribed information and deposit certificate and terms and conditions, then absolutely.
Yeah, no, it's a really good point. We had a question come in as well around do guarantors need to sign the prescribed information even if they don't pay the deposit on behalf of the tenants. My understanding that is that the guarantor, if they haven't paid the deposit, they wouldn't be listed on the prescribed information as a relevant person, but they would likely, as you say, still be given the paperwork probably, just in terms of being prudent around that. So that's a good point, Laura. We've got a couple of questions that have come in around sort of student lets. So one of the questions was, what if the tenants are not students? I expect that this question is really in relation to whether guarantors differ in any way for tenancies where tenants are students or not, or is it just discretion of the landlord on what they accept?
There's no difference whatsoever. It's just a case of students usually always have guarantors, but I think more and more young people, and sometimes older people, requiring guarantors these days. I would say the guarantee is equally strict whether it's a student or somebody aged 50 years old.
The only thing I would mention, is something we've had very recently as well, is that actually we had a situation where a student was going to be a guarantor. Well, guaranteeing with what funds if they're relying on a student loan?
Yeah, that's a really good point. Okay, fantastic. Next question. If a tenant has vacated the property with debts and you decide to take legal action in the county court to recover losses, would you include both the tenant and the guarantor as defendants in the particulars of claim?
Absolutely. Yeah, absolutely.
Yep.
If we're trying to cover off and get a judgment and the ability, just because you have an order or a money judgment against the tenant and the guarantor doesn't mean that you have to take enforcement action against both. You've got that option then to assess what you know about the tenant, what you know about their assets, and enforce that order against one or either because they're deemed to be joint and severally liable.
Fantastic. We've got a couple of questions that have come in, I guess, around jurisdiction and assets of a guarantor. So one of the questions is, if the guarantor lives in, let's say, Jersey, does that mean it's in effect unenforceable? And I guess linked to that question, what happens if the guarantor loses their job or income or sells their assets or moves abroad well into the tenancy? Is there anything that we can do?
Well, basically, Jersey, Guernsey, Isle of Man are separate legal jurisdictions. But it's probably easier to enforce there than it is to enforce, say, in Europe or America. Is just a no-go, actually, because it's so difficult there. It's so expensive. But yes, I imagine you could enforce in Jersey. I'm not saying what we've got to realise is the judgment applies wherever it's actually then going and getting that court in a country to enforce it against the people there. And that's the expensive bit. So yes, you go to Jersey and get a firm of solicitors in Jersey to enforce it. Not difficult, but I wouldn't say what the cost would be. And that's the difficult bit for landlords. How much money am I owed? How much is it going to cost me to do it? Is it worth it?
Yeah, weighing up, are you throwing good money after bad if you end up paying, for example, £20,000 in enforcement action in another country, but your debt's only worth £10,000?
But also, you've got to remember, if you bide your time, you've got 6 years, and the person may come back to the UK, they would run to England and Wales, or even if they find Scotland, then you can enforce it then. Might be a lot cheaper.
Yeah, very interesting. Next question. Does the 6-year limitation period apply to enforcement? This individual thought that it related to taking proceedings, but once judgment was obtained, you could wait as long as you wanted to enforce it.
No, it applies there. You might want to jump in this way as well, Laura, in a second. It applies to enforcement as well, but you may be thinking of a lot of debt collectors, etc. These people who buy banks of debt from Barclays Bank and all sorts of things. What they do is they phone you up, say, Michael, they persuade you to pay them £1. Your 6 years starts running again. So that's what it is there. Do you want to add to that, Laura?
Yeah, and it may also be possible to apply to the court to extend that limitation period. We have seen that happen as well. If there are, reasonable reasons why you haven't perhaps enforced the debt or situation has changed, make an application to the court, you may be able to get that extended.
Fantastic. Next question is, can a landlord take first legal action against the guarantor rather than the tenants? I think you touched on earlier that if you was taking action, you might take it against both. Is there anything to stop a landlord choosing to pursue the guarantor rather than the tenants in the first instance?
Do you want to answer that, Laura?
I guess it depends on what else it is we're looking to achieve. You know, if it's possession, then you're probably going to want to deal with that first, so your debt stops accruing. My preference would be ultimately that you get a judgment against all the parties, and then it's just a question of who do you enforce against. At that point, at least you have got, you know, multiple people that you could perhaps get money from rather than just the one sole person.
Okay, fantastic. Next one. If a guarantor is guaranteeing a tenancy and have given proof of home ownership, if a company is named on that home ownership, would we be able to claim against that company if required?
Yes, you would. The only trouble is people can transfer ownership. But if it's a big company, you're probably reasonably safe. It's of XYZ Limited, might be more worried. But yes, you can claim against the company, no problem at all. Any comment on that, Laura?
No, absolutely. You know, there's no necessary reason why you can't. I mean, hopefully, as part of your due diligence and following out those credit checks, you know, you've identified that at the point of, you know, starting the tenancy and entering into that guarantee. So hopefully there's been some sort of element of covering that off at that point anyway. But also just thinking from an enforcement point of view, if you are looking to enforce, and I know Marvin's mentioned the whole, well, some people may well try and sell assets, for example. But if you've already got, say, a charging order on the property, if the property is then sold, the benefit of the charging order is that you're entitled to your debt to be recovered as part of those proceeds of sale.
And don't forget, it's also the legal costs of enforcing of putting that extra charge, an extra mortgage on the property, and the interest. So you get the whole lot.
Mm.
and just
Actually, gleefully.
Just tied to that around assets, I guess we had a question around, you know, if a guarantor lives in the US but has assets in the UK, would that be equally as difficult to recover, or would that make it easier for a landlord?
Well, if the assets are in the UK, that's fine. It's actually the real problem is enforcing in the US, so it's only assets there. I did actually have one landlord who did manage to enforce in the US, but it cost him a fortune. I'm afraid it was the principle, not the money, that counted. I don't think he ever got a bean, but it gave him a lot of satisfaction. Would you want to add to that, Laura?
No, I mean, yeah, I think I'm aware of the one, and yes, I mean,
yes,
it's eye-watering the amount of costs.
Yes, it was. It was stupendous.
Wow. And the final point that I just want to delve into, we've got a couple of questions that have come in around, you know, how a guarantor status works in HMO situation, if a guarantor only wishes to guarantee, let's say, their child living in either a HMO or a joint property. Have you got any sort of guidance around that? I would imagine, I guess, with a HMO that they're individual tenancies, right? And you would look for individual guarantors for each of those?
Well, yes, if it's a case of an AST for that room in common parts, they're only going to get, you can't really do common parts because who did the damage? It's really just the damage to that room. They're just guaranteeing that AST, and that's a risk a landlord takes. It's a joint and several agreement, and they actually do know each other. I've come across joint and several agreements where the people have never met each other in their life and they try and just fiddle it. You know, if it's a joint and several, and it's an HMO, which you get a lot of them, say especially student properties, then basically a guarantor can be liable for the lot. Any comment, Laura?
Yeah, absolutely. You know, I think if you want to be doing it that way, then it has to be a room-let type agreement. Otherwise, we're kind of getting into the realms of that percentage liability shares. It's whether or not it really meets the aim of all those parties concerned.
Fantastic. And finally, just a final point. We've had a lot of questions around templates for guarantor agreements. You know, we've had a lot of questions for myself too. TDS, we don't offer a guarantor template. Do either of you know of any templates or where people can find these as a sort of foundation to add to some of the knowledge you've given them today?
We've got one where joint and several liable with everything in it, because I wrote it and it's on our shop. And we've also got a limited liability one with a warning of being careful. You have your agents, make sure you get the landlord's written consent. Laura, do you want to give the I'll tell you what, Michael, we'll give you the we'll send you the email. It's just
Fantastic.
www.painsmith.co.uk. But we'll send the details to Michael.
Yeah, fantastic. That's brilliant. I'm going to bring the session to a close there just because I'm conscious of time. Really informative session. A massive thank you, Marvine and Laura. We've had a ton of questions. I'm going to look at whether we can pull some of the common ones out that we haven't been able to answer and try and get some answers over to our attendees in a follow-up. And obviously everyone here, keep an eye on sort of socials as well in case we can try and answer a few there too. Thank you to everyone for your questions and your feedback.
Before we stop, Michael, I see there are 100 questions now. We're very happy to answer them because I know it's a big issue for landlords. And yes, we don't need to have every question, but if you get those that you think are really worthwhile, answer them all. And anybody who is dead stuck, there's our email address there.
Fantastic. Very, very generous of you, Marvine. So, I hope everyone's enjoyed the session and has a great remainder of the day. Laura, Marvine, thank you again. And take care to everyone.
Thank you.